On this morning's docket. It's case number 105588, State of Kansas v. Justin W. Neighbors.
May it please the Court, Stephen J. Atherton on behalf of Justin W. Neighbors. Your Honor, I would request a reservation of 3 minutes for rebuttal.
3 minutes is granted.
The first issue before the Court is the question of what standard of review should have been applied by the Court of Appeals on the interlocutory appeal by the State of Kansas. The Court of Appeals conducted de novo review of this suppression issue, and we would suggest that they had no authority to do so. Their reasoning was that they stated that the trial court had not made any findings of fact sufficient for them to make a decision. I would suggest to the court that based on the Hill versus Farm Bureau decision and the line of criminal cases which also have applied that decision, that there's a presumption that the trial court made the necessary factual findings to support the judgment it made, which in this case was suppression of the evidence. Accordingly, I would suggest that the appropriate standard that should have been applied was a substantial competent evidence standard of review with obviously a de novo standard as to the ultimate legal conclusions drawn.
Do you think that makes a difference?
I do, because I think that they heavily slanted the testimony of one particular officer, that being Detective Delgado, and placed a lot of more credence in his testimony than in any of the other officers that testified. An example being the opinion indicated that Delgado assumed that Mr. Neighbors was armed and dangerous when other officers testified that they'd been standing having a conversation with Mr. Neighbors for 16 to 20 minutes and had no problems with him. He'd been cooperative.
He volunteered that he had a knife in his pocket too, didn't he? Or they asked him if he had weapons, and he
Delgado,
that he had
once
a
he
knife.
arrived, said, "Do you have any weapons?" And he said, "Yes, I have a knife." And again, as I think I stated previously in the briefs, that's not illegal. Certainly, it's a weapon. It can be used as a weapon, but in this particular instance, there had been no showing of any type of aggression by Neighbors whatsoever. He'd been cooperative, he'd been talking with the officers, and yet he was still subjected to this search.
Counsel, before you go too much further, for the benefit of our students, could you give us about a 30 to 60 second recap on what this case is about?
The underlying facts?
Yes.
As much as we tell you not to do that when you do
I
it.
understand, and I understand the reason. Essentially, this was a situation where a landlord went to check on his property, did not receive any response when he knocked on the door of an apartment, opened the door, saw Mr. Neighbors lying on the couch, could not rouse him when he called to him, was concerned for his welfare, contacted the police. The police arrived. I believe there were 4 officers initially, and they eventually managed to get Mr. Neighbors awake. He spoke with the officers. They determined that he had permission to be in the apartment, and then based on the, I'm not sure if it was a 911 call or the dispatch, Officer Delgado and a number of other drug detectives recognized Mr. Neighbors' name as being an individual that they had an interest in, and they responded. They arrived, and of course we're not sure when the determination was made that he was lawfully in the apartment. He was not a tenant, but they did make a determination he was lawfully in the apartment.
But was that made, and you said you're not sure when exactly, but was it made before the 2 other officers arrived?
Well, I think the trial judge said he couldn't really determine when that finding was made.
Okay.
And
I thought Delgado and his partner, when they arrived, were informed that that had happened.
I think they were too, but I'm basing it on
I don't
the
want to
quotation.
just think so. Is there any evidence in the record to support that they were informed? I thought there was some reference to one or the other of them being told within a minute or two of arriving that.
I believe that that's correct, Judge.
Okay.
I think the officer said within seconds of entering the apartment, he was informed that the lady that rented the apartment had given consent. Now, my question is, with regard to the knowledge you were talking about on the safety issue, as well as the consent issue, do we have imputed knowledge when we're looking at determining if an officer has reasonable suspicion or probable cause? We allow that officer to accumulate the knowledge of all officers to make that determination. In other words, what one officer knows, another one knows. Does that work in this scenario also? Would we impute to Delgado the knowledge of the first arriving officers?
I would think so, Your Honor, because what you're dealing
Do
with.
you have any authority for that?
Not offhand, no. What you're dealing with, though, is an invasion of a residence or dwelling, and the Fourth Amendment strictly limits what can occur under those circumstances. And the officers had determined that there was no longer an emergency, not a medical emergency, not a trespass situation, but yet, as the trial court found, there were two investigations ongoing here. The emergency investigation by the first officers, and then the drug investigation by Delgado and his companions.
And we sort of do have a finding with regard to the emergency, don't we? I mean, everyone's sort of assuming, well, there's just no finding, but the court said, I'm going to suppress the evidence based upon exceeding the reasonable time allowed to investigate the well-being or the identity of the defendant, end quote. And so that seems like the court made the factual finding that the time that was allowed for the emergency doctrine had expired.
That's correct. That's correct. And we can't forget that the burden of proof was on the state to establish a lawful search and seizure here. And the court essentially found that the state didn't sustain their burden by virtue of the fact that the court made the comments, which were quoted in the Court of Appeals opinion, that I'm still not clear exactly how much time elapsed between when the officers identified that Mr. Neighbors was legally there or there with the consent of the tenant and when Delgado began his investigation. That burden is on the state. It's not on the defense, and the state failed to establish that.
Counsel, can we go back to fleshing out a few more facts?
I'm sorry.
No,
Yes, absolutely.
You were taking legitimate questions from my colleagues.
I believe we've got to the point
They're
where
in the apartment, and
after entry into the apartment, Delgado talked to the defendant, noticed a blackened Q-tip on the floor, and that the defendant's physical condition suggested to Delgado, at least, that he was under the influence or on the downhill side of meth use. And accordingly, Delgado asked him if he had weapons. He indicated a knife. Delgado then subjected Mr. Neighbors to what I would call a Terry search, a pat down, and then asked him for consent to search his person and performed a search and found methamphetamine on his
And he had multiple pairs of pants on.
Correct.
And so they retrieved whatever they were going to retrieve. The knife was retrieved and all that, and there was no contraband
Correct.
in the outer pair. And so they ended up eventually found the drugs in his boxer shorts after having gone through multiple pairs of pants.
That's
to get
correct.
there.
He was essentially strip searched in the apartment.
So they did more than a pat down.
Yes, absolutely. And our contention, of course, is that once the emergency had been resolved, any further contact, the Terry search, and the continued request for consents constituted an illegal seizure of Mr. Neighbors.
Let me tell you
Even
what
if we
I'm,
were,
let me tell you what I'm wrestling with. And it's the distinction between going in and rendering aid to an unresponsive person and the notion of protecting property. And do you think that under this emergency doctrine or emergency aid doctrine, depending on which law you look at, that protection of property comes under the purview of the emergency doctrine?
No, I don't. And the bottom line, I know at the trial court level, and I think in the initial briefs by the state, they were commenting on the potential breach of the tenant's agreement with the landlord. I don't think that has any bearing whatsoever on what we're dealing with here. This is a Fourth Amendment violation. That is a breach of contract between the landlord and tenant and has no bearing on what occurred. And in fact, law enforcement had no court orders to enforce pertaining to an eviction or anything else. So the other part of this is that I don't agree with the Court of Appeals saying that Maryland v. Bowie, I probably mispronounced that, but would have any application to this. That case refers to a protective sweep when you are executing an arrest warrant to protect the officers. We don't have that here. And that decision does not say that a Terry search is okay when you enter into an apartment. It says that you can sweep an apartment or a dwelling to protect officers' well-being in the event that they are in there lawfully to execute a warrant. We don't have that. Simply put, we have, I'm sorry.
Your contention basically is that what we need to know to decide this case is that there was an emergency and that the emergency ended. Is that correct? And then we're
The
done.
emergency
Then we're
had ended,
finished.
and any continued detention of the defendant or interaction with him at that point was an unlawful seizure.
And if we would say that you really have to infer factual findings from the trial court's words to make that, would you agree that there really are no facts that are being disputed that relate to the determination of there being the emergency and then of the emergency ending? Once,
I would suggest that, yes. I don't think the Court of Appeals agreed with that
Right.
position.
so in your view, that's all we need to know.
Yes. Now, I do agree with Judge Malone, however, that if this court agrees with the Court of Appeals that there was no Fourth Amendment violation to the point that the trial court arrived, we still need to determine whether the consent was voluntary under the circumstances.
Yeah, that's where I was going to ask you, Nick. From that point, once the emergency ends, you think there are controverted facts because you've discussed the safety issue.
Right. I don't think the trial court didn't get that far.
So in your view, if we would say that we need to move to another step of analysis, anything beyond that point, we would have to remand for factual findings?
Yes, I do agree with that. I do agree.
You're asking for a remand rather than
I'm not
saying
asking
that
for a
the
remand.
state-
I'm stating.
Counsel,
Excuse me.
let him
I'm
finish
sorry.
his
I
question.
apologize.
rather than saying the state has the burden and they didn't present the sufficient evidence, so we have an insufficient evidence and so they lose? I mean, why aren't you making that argument?
Well, that's essentially a portion of my argument. My argument is this. The trial court was right. The state did not fulfill their burden of proof at the suppression hearing. However, as I stated, if this court does determine that there was no Fourth Amendment violation, then there are still issues out there pertaining to the consent that need to be dealt with, and they were not dealt with at the trial court level. The judge stopped when he found that the Fourth Amendment violation had occurred. So,
In Seward, with regard to the Jessica's Law, a challenge for a cruel and unusual or cruel or unusual under the Section 9 of the Kansas, we said that there's a concurrent duty with regard to findings of fact that are necessary for review, and that the defendant has an obligation to make certain that the court makes those findings. Why didn't the state have that same burden in this scenario?
well, I suggest that they do. After all, they bear the burden of proof. They did not object to the court's findings. In this particular instance, the court made his findings basically that, and as I've suggested, I think the court pretty well said the state didn't fulfill their burden to establish a lawful search of Mr. Neighbors. And once that finding has been made, it's essentially a King's X. Then the state has to either.
But we've sort of rejected that idea that finding the state failed to meet its burden is a negative finding that's subject to that standard of review.
Every time I'm in front of this court, I make that argument, I
Yeah,
think.
but we've rejected that
Yes.
principally, haven't we?
Yeah.
Any further questions of council? Thank you, council.
Thank you.
May it please the court. Again, I'm Amy Eloranda, Assistant County Attorney. With regard to the issue of the number one raised by Mr. Neighbors, the state would draw this court's attention to its decisions in State v. Parker at 282 Kansas 584. It's a 2006 case. And within that case, this court cited its decision in State v. Jones at 279 Kansas, I believe it's 71, for the, in Jones, this court, the case was submitted to the trial court on an issue of, or on stipulated facts by the parties. The issue was the voluntariness of the defendant's consent to a breath test on a DUI case. And the district court in that matter made no findings of fact on the issue of consent, whether the facts supported the, and this court said that whether the facts support a voluntary consent is therefore for our determination. The court then looked to the stipulated facts for the evidence of consent and determined that within that stipulation of facts, which was in essence a de novo review of the facts presented to the trial court, found that the state had failed to prove through those stipulated facts by preponderance of the evidence that the defendant's consent was voluntary, intelligent, and knowing. So this court has on at least two prior occasions done a de novo review of the facts, underlying facts presented to the trial court in a similar situation.
Is it similar, though, where they were stipulated in that case, and here we have an adversarial hearing?
The state would assert that that doesn't necessarily, there's no difference.
Well, when it's stipulated, we don't have to weigh facts. The parties have agreed to the facts, so there's no weighing of credibility or any of those normal determinations that go into fact-finding. But if there's been an adversarial hearing, we would be in the position of having to weigh credibility to determine which facts we would accept or not accept. Isn't that a significant distinction?
I think if there is substantial competent evidence presented that this court can rely on to support the
That's when fact
Court's
findings have been
decision.
made. Substantial
sorry?
competent evidence only has application when actually we're presented with findings, and then we determine whether there's substantial competent evidence to support them. I think you're mixing up your standards of review. We don't do de novo reviews of facts.
well,
We may
then-
make a de novo determination on a stipulated record, which is what my colleague is suggesting.
Well, that was the closest that I could
Okay.
find where the court
Very
had
good.
done a de novo
The
review.
closest to support the Court of Appeals
Correct.
standard of review. Okay,
Correct.
I
And
understand.
they did make that finding that they could conduct a de novo review.
I have
Was
a,
there any question that Mr. Neighbors was not in custody when the consent was given or under law enforcement control?
I don't believe that was really, no, I don't believe that that was really an issue.
you mean,
I'm just talking about the facts surrounding the situation. He had, there was a pat down and then there was an additional request for consent to search. He was still under law enforcement control at that time, wasn't he?
Arguably, yes, there were 6
I mean, he couldn't have
police
got up and said,
officers
no, I'm
and-
not going to do this, and got up and left, I don't believe.
Correct, I don't believe so.
Okay, thank you.
I have another question. It looks to me that the facts establish that there were at least 3 investigations going on. There was the first emergency situation. Is he alive? Does he need assistance, et cetera? The law enforcement knew that that wasn't a problem as soon as he was up and talking, correct?
Correct.
Okay. And then there was number 2, is he trespassing? Which was really a concern of the landlord, but that got disposed of as soon as they established that he had permission to be in the apartment, correct?
The issue, yes, well, yes.
The landlord
I
doesn't get
believe-
to grant permission beyond the tenant. Once the tenant said, he has my permission to be there, the investigation, such as it was, of trespassing was disposed of, correct?
Correct.
Okay. And then we had the third investigation of drug use or possession or distribution or whatever. My colleague at the end of the bench, Justice Files, asked a question of your opponent about how far the emergency doctrine extends. What's your view on whether the emergency doctrine extends to the protection of property versus the protection of someone's welfare?
Well, I'm not certain that it extends to,
Does it or does it not
Well, I
extend to
believe
the protection of property, as in
Court of
the
Appeal-
trespass investigation here?
right. The Court of Appeals, I believe, addressed that and indicated that they believe to some level that it did extend to the
Does it or
protection
does
of
it not in
property.
your view?
I think the officers on scene have evidence that, I think that the problem that I struggle with is that the emergency doctrine initially gives them permission to be on the premises, but they can't ignore their observations and things that they see once they're on the premises. If they would obtain information that indeed the defendant had some intent to destroy the property of another, then I think that probably under those circumstances, they would be duty-bound to,
See that here? He was asleep on the sofa.
probably not in this
Okay.
circumstance.
So we've got at least the potential as a matter of law here that they couldn't even extend to a trespass investigation, right?
I'm sorry, say that again?
We have at least the potential here that it was unlawful even to go on to the trespass investigation, much less the drug investigation that followed it. He wasn't doing anything that would have led, or do you have facts in the record that support that he
think
was
that-
doing something that imperiled the property of this tenant?
No, we have nothing
landlord.
that would impair, that I'm aware of. I wasn't trial counsel, and I read the transcripts. the
Nothing
best
in the
and
record.
Made myself familiar with the facts the best I could, but I'm not aware of any facts that they believe that he was going to or had distracted property that did not belong to him.
Okay.
I think that the information that they had going in, though, was twofold. That there's this unconscious man on the couch inside. We can't get him roused. He may need medical attention, and he's not supposed to be there because
And he's not the tenant.
Correct.
He's not supposed to be there. They didn't know that. What they knew is he's not the tenant.
Correct. And they did not know if he had committed a burglary or was lawfully on the premises with the consent of the owner.
Would you agree that plain view doesn't come into play until Detective Delgado comes on the scene? I mean, he's the first one that sees anything that he would consider possible evidence of a drug situation.
I think the record reflects that that would be accurate, that Detective
So-
Delgado was the first to articulate a belief that there was drug paraphernalia based on his training and experience in plain view.
So is it critical to your position that we have to find that Officer Delgado entered the apartment legally?
Yes.
And what is your argument for that? Under the circumstances where by that point in time, Mr. Neighbors was alert and at least somewhat alert and visiting with officers.
Right.
So
I think
it seems
that
the emergency may have ended by that point.
The emergency may have ended by that point, but I believe that our brief that was submitted to the court did cite to portions of the record wherein the facts reflected that Officer Delgado came into the apartment, and within 5 to 10 seconds of his entering, he immediately went to the defendant, saw the drug paraphernalia, the Q-tip, observed the defendant's condition, and asked if he had any weapons, and got a positive response.
He still had to be there legally.
Correct.
All of that had to be
Correct. In the office.
legally in position, and that's Justice Luker's question.
Correct. We cite two portions of the record wherein, and I believe it was Officer Doty testified to confusion at that point, whether, and remember there was another individual in the apartment as well. There was a female in a similar physical state that was found in the bedroom, and they initially maybe had some information that at some point that Mr. Neighbors was lawfully on the premises with the consent of the tenant, but this other individual, this female in the bedroom, there was confusion whether she could still be there, and they were still on the premises trying to determine
That's the
her.
investigation of the trespassing, isn't it?
Correct.
And what's your justification that they had the right to be investigating the trespass at that point?
That they had received information from the landlord that these two individuals were not the tenants.
I didn't ask a very good question there, because they may have had information to investigate a trespass, but what was their right to have entered the premises for the purposes of that investigation, or to remain on the premises for that investigation at that point? A difference between reasonable suspicion that may have allowed an investigation, but not a search.
I guess I don't understand exactly. My understanding of the facts is that they had information going into the apartment from dispatch of a potential trespass, and this individual may need some type of emergency assistance.
Back to my question, once the emergency resolved, what was their legal right to continue to remain in the apartment?
That they believed that they had information that these two individuals may be trespassing on the premises, and they were trying to gather the information by having to call the tenant, who was, I believe, incarcerated in Morris County Jail, and they initially asked about Mr. Neighbors, and then this other individual was located in the bedroom, and there was confusion whether
At that point,
whether she had been in the premises. When Officer Delgado entered, they were still, my understanding of the record is that they were still attempting to ascertain her ability to lawfully be on the premises as well.
But at that point, Neighbors should have been able to sit there unmolested or be free to leave, because things were disposed of as to him in terms of his physical welfare and the trespass.
I think that
Yes or
and
no?
he was, yes.
Okay, I have another question. We talked about the legal standing on protection of property in the emergency doctrine. I'm going to give you a hypothetical.
Okay.
He wasn't asleep on the sofa, he was just in the apartment. Landlord comes around, wants to collect the rent, knocks on the door, he doesn't answer it. Landlord can see from outside that this other person who's not a tenant is in the apartment. Trespass doesn't justify an emergency entry, does it? If it's only the landlord says he's not the tenant? If I rent an apartment
Probably
and I have
not.
somebody on the premises who the landlord doesn't happen to know, but has my full permission to be there, that doesn't permit the law enforcement officers to go in, does it?
No,
So that the emergency entry was dissipated
correct.
by the time Officer Delgado arrives on the scene. And all that's going on is a trespass investigation. More law enforcement can continue to pour through the door because initially Mr. Neighbors was asleep rather than walking around. How many police officers does it take to determine that he's awake and conversing?
I don't know that, but once they've have a legitimate reason for,
To go in, it's open season.
but
That's your
once they're
argument.
in there, they have, and had gone in there, they had the
Even
additional
though the reason for
information.
entry has gone away.
Okay.
They can just continue to pour in and continue to find suspicious things and search high and low.
Probably not. No, I would agree that they do not, but I think that under the facts, it's fact specific that and the
I have
timing
a
of how these
fact
things
question
occurred.
here. I have a fact question. Delgado and is it Dudekin?
Dowdykin.
Dowican? Both arrived at 10:50 a.m., which indicates to me, I think they came together, correct?
I believe so.
Okay.
Or relatively,
And then Dowican testified that he was informed that neighbors had permission to be in the apartment, quote, within a couple of seconds, end quote, of his entry into the apartment. And he immediately went to the back bedroom and talked to the female. Did he enter after, before, or at the same time as Delgado?
it's my understanding that he entered, I don't know. Honestly, I don't know if it was
But-
at, before, or at
Well,
the same
my
time.
point
but-
is, if we impute the officer's knowledge to both the deputy and to Officer Delgado, then when they entered, there was no emergency. And I think Delgado testified that he believed that there was emergency from what he heard on the dispatch. But if we impute
To him.
that knowledge to him, that he had the same knowledge that his partner had when they arrived, then what basis would there be to enter? And if he couldn't enter, he's the only one that saw the Q-tip and had the training to relate that to meth, then we sort of lose that whole string of evidence, don't we?
Well, I think if the other officers on the premises did not have a lawful reason to continue to be there after the emergency ceased, then I think what you're saying is correct, that the information imputed to
Well,
Delgado and Dowdykin.
Their investigation of the trespass had ceased. By the time Dowdykin entered, he said within a couple of seconds of his entry, he was told that neighbors had the right to be there. So the investigation of trespass with respect to neighbors, even if that was permissible, that had ceased also. So we got the 3 investigations, and 2 of them had been cleared by the time that the deputy that entered about the same time as Delgado arrived and entered. And so then what basis is there for them to go in to do a drug investigation, to observe the Q-tip, and to observe his demeanor?
Well, I think it's then just a matter of if they came in together, and I believe the testimony was from Delgado that within the first 5 to 10 seconds, he's making and these things don't stop, come in slow motion. These are happening simultaneously, and he's explaining that he's seeing these things and taking all this in at the same time, and his specialized training, he asked
How can
neighbors
we
if he had a
infer?
knife.
How can we infer that the officers had not already cleared the trespass investigation with regard to neighbors when Delgado came in, when they had already cleared it when Dowdykin came in, and they both arrived at the same time? How can we infer that Delgado got in there and observed the evidence before the on-scene officers cleared the trespass investigation? It's just the opposite, isn't
Well,
it?
I think that the state's position is that they might have cleared with regard to neighbors, but there was another individual in the apartment, and they were still trying to determine her lawfulness on the premises. Ms. Stoll was in the back bedroom, and that is when Dowdykin went and contacted her. And within these first
He contacted
few
her
seconds,
because he recognized her name as being a drug user or involved in drugs. So that's not clearing her as a trespasser. It was to do with the drug investigation.
well, it might have been twofold. In the state's opinion, it was twofold. I mean, if they have a lawful reason to be where they're at, if they have, just like a pretextual stop, if they have other motives as well, as long
They
as
don't have to
they're-
close their eyes to other evidence, and they can do concurrent, but they can't measurably extend the current detention
Correct.
to do the
I would
drug.
agree with that. But I think what this hinges on as well is that within these first few seconds, Delgado asks him, "Do you have a knife?" And I believe the record reflects that Delgado believed that he was going to reach in his pocket and get the knife out for him, and he said, "No, let me help you. You know, don't get the knife out yourself." And obviously, and he articulated that as an officer safety issue. And at that point, he did the pat down of the outer clothing and removed the knife. Then, as he's simultaneously taking in his demeanor, the profuse sweating, the manner he's dressed in, Delgado's knowledge of his Mr. Neighbor's history of drug use, the Q-tip on the floor, he asked him if he would consent to a search of his person.
And that's my
was
question here.
granted that.
I asked previously, was there any point in time in which Mr. Neighbors was free to leave after the initial entry of the officers? Was there a time in which he said, "Nope, I'm not going to consent, I'm leaving"? I think you were getting ready to say that he was free to leave at some point, and is that right or not right?
No, I wasn't going there, but,
Okay.
and I don't believe that he was ever advised by any officer that he was ever free to leave. And arguably, he probably was not free to leave at any point because they were trying to determine, once they determined that he was not in any kind of a medical emergency situation.
And that he
they were
wasn't a
trying to-
trespasser, he was still not free to leave.
And again, I think it's because of the sequence of the events that it wasn't conveyed to him, and Delgado came in and made these observations almost simultaneously with the other officers still conducting their investigation.
We can agree that when Officer Delgado stepped through the threshold of the apartment, he was not there to render emergency aid to anyone, can't we?
Probably not, because I believe, if I recall, and again, I'm sorry, I was not trial counsel, but my recollection of the facts as he testified to were that it piqued his interest because he knew the history of the names of the individuals that he heard over the radio.
He was there looking for drugs.
I believe that was probably his intent, was to see if he had been involved in any, and I'm sure that with the knowledge that, well, I'll stick to that because I don't want to make any reference that I'm not positive of in the record.
So the Court of Appeals was wrong when it held that Officer Delgado walked through the threshold responding under the emergency aid doctrine, because that was their holding. They looked at it from his perspective as if the other officers had never been there. And you can't do that. That's always been kind of the goofiest part of the Court of Appeals decision from my reading of it.
Well, I guess if you can impute knowledge back and forth one way or the other, then yes, it was, the emergency was imputed to him, but did he go there, did he respond after hearing the dispatch because he thought that they still needed his help? Probably not. I'm sure that he testified that he recognized the names, and I think that's stated in the record.
Counsel, you're way over your time, but would you like about 30 seconds to wrap up?
I guess I would, I think we've made our point, and we've submitted our original brief, and I hope I've answered all of the court's questions. Thank you.
Any further questions of counsel? Very well, thank you. You reserve 3 minutes for rebuttal.
Very briefly, I can't recall specifically whether it was the trial court or whether it occurred at the Court of Appeals, but a reference was made that this was a knock and talk without a knock. And that's exactly what it was. Delgado came in. There wasn't an emergency at that point. There wasn't a trespass issue. And the bottom line is, if he had reasonable suspicion or probable cause of drugs in the apartment, he could have gotten out, gotten a search warrant, and proceeded to search lawfully.
Not with reasonable suspicion, he couldn't.
Well, not with reasonable suspicion. Probable cause he would have had to have. And a neutral and detached magistrate would have to assume that the Q-tip, blackened Q-tip, was enough. Because as the trial court found, there wasn't any other, I think the judge actually said there was no evidence of drug use in that apartment. The bottom line is, we would ask that the court affirm the district court suppression order.
And the Q-tip, the testimony was the Q-tip was used to is typically used to clean the glass pipe that's used to consume.
That's correct. However, Delgado, I believe, confirmed that he used them for cleaning his guns, that his wife used them for makeup. There's numerous uses for Q-tips. Are there any other?
Any further questions? Thank you, counsel.
Thank you.
We thank you both for the arguments this morning. Court will take this matter under advisement.